You have a quorum, Madam Chair.
Thank you very much. We have a fairly light docket today, but I do want to take note that Carl Ayers is, and I hope Carl is with us. Don't see him, there you are. Carl, I think you should come forward. We want to say a few words of recognition and thank you. You have been with the department nearly 24 years, and you've been in the business of social services much longer, but you have been an incredible resource. You've been a great leader. Fortunately, our human service programs have gone through, I think, important transformations because of your leadership, and they're now, I think, a bit more seamless, hopefully more user-friendly, and I know that they're helping our families really become self-sufficient. I just wanted to take a moment to thank you.
Carl, did you hit the lottery?
Pardon me?
You hit the lottery?
No, sir. If I did that, I'd be happy to share it with you, some friends.
Mr. Chairman.
Yes.
Madam Chairman,
That's
excuse me.
right.
Senator
Senator
Sproul, the
Mason.
Casey Family Foundation is stealing call from us. I want to make that very clear. But no, I have had the opportunity to work with you and your team for the last couple of years on all the Family First work, which is just a complete restructuring that y'all started from scratch. And, you know, you brought me along having no background, no knowledge base whatsoever. And I think we can't thank you enough for the work you've done for the Commonwealth of Virginia and for children for the last 25 years. And so I know that'll continue somewhere else, but don't go far because we know where you live. And
You do.
we wish you the best, but you've done great work for us, and we can't tell you how much we appreciate your effort.
Thank you. Thank you, Madam Chair and members of the committee. Many of you have had the pleasure to work with individually on a lot of different legislation and across both sides of the aisle. And our children and families, I truly couldn't agree with Senator Mason anymore. We are so much better with our children and families, and they are served so much better today because of the work we have done in this committee and across both sides of the General Assembly. So thank you for letting me be a part of that, and I hope that in the future our paths will cross. And I'm still a Virginia resident, even though they'll be flying me all over the country to do other work. I'm still a Virginia resident and still look forward to working with you.
I still have your cell phone, so we'll.
Yeah, you did. So.
We won't forget what a great resource you've been. So best of luck, and thank you again.
Thank you very much.
Okay, we're going to take care of some what I would consider housekeeping items. The first bill before us actually is House Bill 1436. I don't know, Delegate Jones does not have to be here because that bill is identical to Senator Mason's bill, 583. Senator Mason, you want to give us a one-sentence explanation and maybe move adoption?
So it's a distillery board. We got to find money to operate it, but we're trying to grow the industry and want to keep on going. He does have to swing by finance and make sure you tell him that there's $0 attached to that. So I've moved we report and refer this bill to finance.
Thank you. That's the correct motion. Is there a second? Okay, it's been made, motion made and seconded. Please open the rolls.
Eleven ayes, 0 nays.
Okay, bill passes. Thank you.
Hey, Sproul, don't forget you got Mamie's box down there.
Yeah. Oh, sorry.
You okay?
Chad, did you get that? Thank you so much. Okay, now there's a similar bill. It's a bill that's similar to mine, and Delegate Keem is here, and this is the Fostering Futures. Why don't you give us a one or two sentence explanation?
Sure, even shorter than that. First of all, happy Valentine's to everyone, except for Doug, Senator Somerville there. My House Bill 400 would codify the Foster's Futures Program. And Madam Chair, as you know, being the chair of the Virginia Commission on Youth, this is one of the most important bills that we looked at this year, and as the Commonwealth is going to provide more opportunities for those students and young people who are aging out of the program. I don't know how much differences there might be between the two versions, because I know we've had some technical changes along the way.
Yes, I read both bills, and there's only a slight change. In your enactment clause, which I think is a good idea, you actually ask the department to evaluate the appropriateness of using technology
That's right.
for the site visits. Because these, in Fostering Futures, the youth are between the ages of 18 and 21. So if they can use Skype and other means, as long as we conform to federal requirements, that actually would be easy, and we'd have more connection opportunities with our youth. So that's the only difference. Otherwise, the bill is exactly as mine, and the Senate bill passed 40-0. So I would like a motion.
Move the report.
Second? And, okay, motion has been made and seconded. Clerk, please open the roll.
12 ayes, 0 nays.
Thank you, Madam Chair. And obviously, I'll talk offline, but when your bill comes to the House side,
I think I may add your
yeah,
your
we'll make
language.
sure it's the same language.
I like it, yep.
Thank you very much, Madam Chair, and members of the committee. Thanks.
Thank you so much. Okay, other bills before us. Delegate Hope. Is Delegate Hope here? He's not here yet. Delegate Goditis. We'll get right to you. I don't think Delegate Goditis would take too long. Delegate
absolutely not.
Goditis, welcome.
Good morning, Madam Chair, members of the committee. Which bill would you like to hear first? We have HB 1482.
How about HB 287 first?
Okay. So HB 287, it just keeps the unfounded records from social services for 3 years as opposed to 1 year as it stands now. And all that does is it aligns that with the current practice of keeping family assessment records for 3 years. So
It's a best practice, actually.
Yeah.
So it's a good idea, and it passed the House 100-0.
it did.
Okay, motion has been made and seconded. Please open the roll.
Twelve ayes, 0 nays.
Thank you. Okay, what's your next one, Delegate Goditis?
HB 1482.
1482.
Madam Chair. This has to do with the appeals of civil commitment orders. So Virginia Code contains 2 different statutes for appealing ICOs. One is basically supposed to be for, I feel better, so I don't need to be here anymore. And the other one is supposed to be for, I never needed this, you got this wrong. So right now, the code is unclear as to which statute people should go to. So this clarifies, it just clarifies which way to go.
For just, this is more of a process clarification?
Yeah.
Okay.
We do have someone here who can be more intelligent on this subject than I.
Is this an administration spokesperson?
I think we have someone here. We have someone here?
They didn't answer the phone call.
Hi.
I'm Mike Schaefer from the Department of Behavioral Health and Developmental Services.
Welcome.
The administration hasn't necessarily taken an opinion on the bill. We did share a slight suggested amendment to Delegate Goditis yesterday, not to harm her bill. But as it's written right now, it references Section 18.2-845. That section of the code is actually applicable to people who continue to be confined, and her whole bill talks about people who have already been released. So the Attorney General suggested striking that language because it's confusing, because it's inapplicable to the category of people she's talking about.
I'll ask David May if he has that exact language, and if you could just read
Fine.
it to us, we'll accept the amendment.
Madam Chair, the line amendment would be on line 34 after section 37.2-844, strike section 37.2-845.
Thank you, and I apologize. I
No,
forgot.
all those in favor of the amendment signify by saying aye. Aye.
Madam Chair.
It sounds like it was unanimous. Yes, Senator Mason.
Mr. Schaefer, could you just give us a real life situation that what this is trying to help us take care of?
So what we heard on the House side is from an attorney is when people get involuntarily committed and committed to a facility, oftentimes they're released and then they want to file appeal. Right now, there's confusion under what is the proper venue for the appeal. Do they file where they were committed or where they were at home? Because sometimes people get committed in jurisdictions far away from home. What her bill does is just clarifies what are the proper venues for the appeal of the commitment.
Yeah, it seems much clearer now.
Madam
There's
Chairman.
excuse me, Senator Serbo.
I'm still really confused. So,
Okay.
first of all, what, we're talking about people who have TDOs in it, right?
Yes, they're under
Okay,
TDO
now,
and then they have
Further
an
question, Madam Chairman?
Yes, Senator Serbo.
Okay, so in my jurisdiction, the way I've seen it work is somebody gets a TDO, they go down to Woodburn next to Fairfax and Nova, and they get put into a Nova hospital in a mental health wing. They stay there for 48, 72 hours, then there's a hearing, okay?
Yes.
And a hearing is before a Fairfax County General District Court Special Justice who's been appointed by the General District Court to hear that in the county where they live, right?
Correct.
Okay, further question, Madam Chairman?
Senator Serbo.
So at that hearing, lawyers come and they both present their case. The person can either voluntarily choose to commit themselves for a period of time, or if they don't do that, there's a hearing. And if a judge makes a finding that they're a danger to themselves or others, they can be involuntarily committed for a period of time. That's what we're talking about, right?
Yes.
Okay. Further question, Madam Chairman?
Senator Serbo.
So if you don't like, if the person who's on the receiving end of that order doesn't like it, they can note their appeal, and because it's a Fairfax County General District Court proceeding, it's heard in Fairfax County. Is there some ambiguity about that?
Madam Chair, Senator Ravel, in your situation, there wouldn't. What in the situation that would cause some confusion is in that scenario, but then say, for example, the TDO was issued in Fairfax, but then the person got sent to Central State Hospital in Dinwiddie County, and then they're committed in Dinwiddie County. They have that commitment hearing within 72 hours of the TDO. Then the question is, they want to then appeal their commitment, do they appeal in Dinwiddie County or do they appeal in Fairfax County? And it's specifically confusing in cases, they say they were committed and 4 days later they're released from the hospital, they go back home to Fairfax. Do they have to go all the way back to Dinwiddie County to appeal, or can they appeal in their home
Madam
community?
Chair, further question.
Senator Serbo.
I don't understand why it would ever go to another county. I mean, at least in Fairfax and all the jurisdictions in Northern Virginia, it's a Fairfax County General District Court proceeding. That's where the papers are initially filed. And so the appeal would be to Fairfax County Circuit Court. I mean, is there something in this statute that's ambiguous about that?
Well, Madam Chair and Senator Servo, if someone, again, went to Central State Hospital, it would actually be the Dinwiddie General District Court who does the commitment hearing.
Right.
And so then again, if they are committed in Dinwiddie County, they then subsequently get released, they are still wanting to appeal their commitment, saying, I should have never been committed. There's ambiguity of whether or not Dinwiddie is the proper venue for that Dinwiddie Circuit Court is the proper venue because it was a Dinwiddie General District Court that did the commitment, or can they file in Fairfax where they are from?
So this is clarifying for the patient
Yes.
and the patient's advocate where the appeal would rightfully go. Is
That's
that
my understanding.
Madam Chairman, further question.
Senator Servo?
Okay, I get everybody thinks we're trying to clarify it. I don't understand what we're trying to clarify. You file a case in one General District Court, it goes to the same circuit court. That's how everything works. I'm not clear what's ambiguous about that. I mean, you don't appeal in the Fairfax General District Court, and then because you got transferred to Petersburg, end up having your case transferred to Petersburg. I've never heard of a case that works like that, of any kind.
Madam Chair, if I may.
Yes. Yes, Delegate Godinez.
Madam Chair, Senator, I don't think what this bill does has anything to do with locale. This only has to do with, this came to us from our local CSB in Loudoun, and then the Virginia Association of CSBs supports this bill. All it does is tell people which statute to use, because there has been, oh gosh, I wish I could give the example. So if
There is a gentleman standing behind the pole who seems to want to speak. Did you want to speak?
Well, I'm Bruce Cruiser with Mental Health America, Virginia. I'm not an attorney or an expert on this. I just know that we support the bill because our understanding is it does clarify for someone appealing under which code section they should make the appeal, depending on whether they are appealing, if they're still in the hospital, or whether they've been released and they're appealing due to the other implications of having that TDO on their record. So my understanding is it clarifies the process so it protects the individual rights and it's clearer to them as well as to the attorneys.
Not that it's necessarily changing anything, it's
No. it's-
clarifying.
Right. Thank you.
Senator Morrissey.
Good morning, Delegate. Good morning,
Good
Delegate.
morning, Senator.
Here's a question I think that Senator Servell is addressing. And he used a comparison for something other than a TDO. It's frequently the situation that a person may be arrested, we'll call it in Central Virginia, on a criminal offense, has his first appearance in General District Court, but that person is sent to a regional jail, say the one in Hopewell. Everybody knows that irrespective of whether that person is released from the Riverside Detention Center or remains there, he's going or she is going back to Henrico, Richmond, Hanover General District Court. Senator Servell, I believe, is requesting why, and that's not confusing. Everybody knows that's the course of action. I think we maybe just need some clarification on why we need more specificity here when we already know the court that the person returns to or the court that the person appeals to.
I can ask General Counsel if that would help.
That would be helpful,
drafted
Madam
it.
Chair. Thank you, Senator Morrissey.
Okay,
Madam Chair.
Excuse me, let me ask General Counsel to respond to Senator Morrissey's question, and then I will take other questions. So I don't know if you had an opportunity to hear Senator Morrissey's question, but he very briefly, do you want to explain your question, Senator Morrissey, very briefly, and
Sure.
I'll ask David May to respond.
It's pretty clear right now that when somebody is transferred to, for example, a regional jail, we all know where jurors, say Hopewell Regional, Riverside Regional Jail, they're going back to the court where they face charges, whether that's General District Court in Richmond, Henrico, Hanover, et cetera. Everybody knows that if a person appeals from that General District Court, they're going back to the Circuit Court. There seems to be maybe some confusion, and I think that's the idea behind the delegate's bill to clarify venue when, and Senator Servell says, is there any confusion? And if you could address that.
Madam Chair, Senator Morrissey, so everything you said there is correct. What you would have here is, if you look at lines 33 to 34, that's really the only thing that the bill does, is that one sentence that starts with, if the person is released during the pendency of appeal. So that language is important in that this only kicks in when the person has already been released. So if the initial hearing was in Dinwiddie, they would have had to have filed an appeal there, I'm assuming, and have been released. And then under the provisions of this, if you look at 372846, it then says the petition can be filed in the circuit court in which you reside. So I'm not sure if the appeal would actually be moved over, or you'd be filing a new petition. I'm not really sure how this.
Therein, Madam Chair, lies the confusion.
Senator Morrissey.
Central State is located in Dinwiddie. Am I correct? Should know that, my jurisdiction. Here's the confusion that Senator Servell was addressing. As you said, the last line on 34 says when the person is released, he goes back to Fairfax County. Now there's the possibility with this new legislation that that appeal would be handled in Fairfax County. But the original filing is in Dinwiddie, and I like what you're trying to do, but I think it's going to cause some confusion between where the paperwork is. That is what Senator Surville was focused on.
Okay, thank you for the
Madam Chair?
clarification.
I have my hand
Okay,
up.
colleagues, I'm going to take you one at a time, and if the patron wants to interject, she may. Okay, Senator Sproul, and then Senator Boysko.
Madam Chair, it seems like we're gonna be up here all morning, this one bill, so we have patients who are waiting. So if we can't work it out here, can we bypass this and hear everybody else so we can get out here in time?
Well, the question before us, and that's not a bad question, I don't know if any clarifying language could possibly be helpful, but if it might be helpful to you, the Delegate Goditis, if you wanted to just spend a minute talking to the department rep and maybe trying to find some clarifying language, is that?
Madam Chair, I put it to you and to the committee respectfully, again, that this sentence has nothing to do with the location. It only has to do with which piece of the code you use for the appeal. Are you appealing because you feel better and now you're okay? Or are you appealing because it should never have happened in the first place? It really should not have anything to do with the locality.
It's not changing the location.
Not at all.
It's really,
Not at all.
okay,
Madam Chair,
yes.
And I would wonder if,
Senator
sorry.
Bryce.
Okay.
if I can bring the committee's attention to line 16 near the end, it says, "The court may transfer the case upon a finding that the other forum is more convenient." I think that leaves the discretion to the court of where the venue should be. We didn't change that language, and I think that answers pretty much all
That
the
answers the
questions here.
question.
So
I think that's it.
I would move to report the bill. I think it's
Okay.
in good standing.
All right. Motion has been made and seconded. Clerk, please open the roll.
Fifteen ayes, 0 nays.
Thank you. Thank you for your patience with us.
Thank you, Madam
all right,
Chair, members of the
Delegate Goditis. Good morning. Okay, is Delegate Hope, where,
I have two bills. Senator, I know you wanted to incorporate one of mine.
welcome, Delegate Hope. Now, we did have a conversation, and I believe you are going to hopefully agree to roll in House Bill 1093 into Delegate Aird's 1467.
That's correct. Yes, that's correct.
Okay. May I have a motion to do that?
So move.
Second. Oh, we cannot. We can only roll Senate bills, so they're both going to go forward. One of them can strike. Would you be willing to strike your bill?
If that's the way. the Senate-
And then
it's
we
not the
can
way the
add
House
you as
does
a
it.
chief co-patient. No. Okay. Motion has been made to strike Delegate Hope's 1093 bill. Is there a second?
Second.
Okay, we have to open the roll for this. You're striking a bill. Okay, now we're going.
15 ayes, 0 nays.
Okay. So,
He has 2 to 1, Madam Chair.
excellent. I would like to now hear from Delegate Aird on House Bill 1467, and I believe we can add you as a chief co-patron?
Great, yeah.
Okay, Delegate Hope, you'll be added as a chief co-patron. Delegate Aird.
Good morning, Madam Chair and
Thank
members
you.
of the committee. Prior to explaining the bill, there is an amendment that I'd ask the council to report.
Okay, would like to see the amendment.
And Madam Chair, would you like me to explain the amendment at this time or?
Yes, please, go
Okay,
ahead.
thank you. Madam Chair, this is legislation that would direct both prisons and jails to assist with providing inmates with identification upon their release. The amendment before you is at the request of the Department of Corrections to clarify the process. There was language in Section A that would have required them to issue a special identification card. And this amendment just really allows it so that if they were not able to acquire the birth certificate or the Social Security card, that they would then receive a prisoner identification form, which is also a legal form of ID.
I think it's
Council, did I leave anything
a
out?
good idea. Okay, the amendments have been moved in a block, and there's a second. All those in favor signify by saying aye. Aye. Anybody opposed? Amendments pass unanimously, and
Thank you. And so, Madam Chair, members of the committee, ultimately, this legislation is about just trying to ensure a seamless process for individuals upon their release so that they can obtain employment, housing, all of those things that will help them reintegrate into society.
I think it's a great idea. Do you have anybody in support? Anybody in opposition to this bill? Okay,
Good morning, Madam Chairman and members of the committee.
good
I
morning.
stand in opposition, thinking that maybe we would take up, you all would take up Delegate Hope's bill, because we're not opposed to the concept of helping the inmates when they leave. Delegate Aird's bill goes much further. It requires that we deal with a birth certificate and social security card, services that many jails are not doing now. So in many of the jails, we already do the card, some from DMV, some not from DMV. And Delegate, the other bill was not mandatory. This bill is mandatory. After 90 days, the sheriff and the regional jail have to provide the service.
I thought it read, you have to come up with a procedure.
That's what it says.
It's a procedure.
It says come up with a process.
It's, you have to come up with a process. You don't have to provide the end result, is how I read the bill.
So the impact is significant on the jails. We're currently 691 jail positions short, and this is going to be an additional burden.
Madam Chair,
Yes, Senator McPike.
lines 31 through 32 say that the cost will be borne by the prisoner. How is the additional burden?
The cost, Madam Chairman, Senator McPike, the cost, I believe, in Delegate Aird's bill is borne by the sheriff.
Madam Chairman?
Not,
That's not the way it reads.
Madam Chairman, I think there,
Senator McDougal.
I think that there's two separate sections. The lines 31 and 32 are applying to the Department of Corrections, and I don't think that that's,
Lines 50 through 52 as well says if it's indigent, that's the only instance in where. Madam Chair, we amended the bill in the House Committee to ensure that the cost would not be passed on. And so I'm not clear on the reference that's being made at this time, as that was not shared with me after the bill was amended to try and address what is being referenced at this time.
Yes, I can see that. We still, even though the way it's worded does
And
not
even-
appear to have an impact on the department, our Finance Committee has asked to see the bill if we report it out.
That's fine.
So,
And we had this discussion in the House, and it was clarified that with the language adding in that it's merely a process, and even if they aren't able to, if they are unable to obtain the actual documents, that they would just have the forms completed to begin it for them prior to their release.
Okay, well, hopefully this will be
Madam Chairman?
very clear to Finance. Senator McDougal?
I am in favor of the concept, but I'm trying to reconcile the language in B and the language in C. They seem, the language in C seems to say what Delegate Aird just said. I think that says shall establish procedures for, but in B, it seems to say that they shall provide the assistance necessary to. I'm just, maybe a staff could tell me, Mr. May, how those two interplay.
Mr. May?
Madam Chair, Senator McDougal, so I will say, in addition to the amendments that you have, we do have one more that we need to put on to fully accomplish what the delegate wanted to do. I don't know
Okay.
if you wanted me to add that and
Please,
then explain how that all
no,
works.
please add that, and then you can explain how the bill works.
Okay, the other additional amendment would be on line 16. At the end of the sentence there, we would add another sentence that would read, if the prisoner is unable to obtain the special identification card prior to his release, the department shall supply the prisoner with the Department of Corrections offender identification form upon release. So what this would do effectively is, under A, assuming the department can get the necessary documentation They have to provide any assistance necessary to the prisoner to make sure that they can get this government-issued identification card. In the situations where all of that documentation is not available, then the department, this would not apply to jails, the department would have to give them this Department of Corrections offender identification form upon release. So that's what A does. When you jump down to B, you're just looking at the original birth certificate or social security card instead of the ID. So it goes on to say that they have to assist them in applying to get those documents as well. And then when you jump down to C, that's where you're really just talking about the development of their procedures to make all of this happen. And then the D is obviously about the cost.
Madam Chairman?
Senator McDougal.
Delegate Aird likes that amendment for the first one. I think.
I'm sorry, I thought that's what we reported. I thought that was what we reported. I apologize about that.
No
I
problem. I'm
think
going to
that's-
ask that we adopt that amendment.
I'll move that.
That is
And
at
then I'll
the-
get to my
Motion has been
question.
made and seconded, and all those in favor signify by saying aye. Aye. That line amendment's adopted.
So,
Senator
Madam
McDougal.
Chairman, the first code section, 31.4, I don't think that there's a question. DOC is a big entity. They can set up processes. The question, I think, is coming for the jails, because some of them are smaller and don't have the same processes as an individual. So in that section B for a jail, in that second code section versus section C, just tell me if I'm reading this wrong, that says that if they don't possess, if the individual does not possess birth certificate 1 or social security card, then they shall offer to provide the assistance necessary to apply for those things, and I read that shall to apply to the section 2, and then C says establish a process. So I'm trying to see why those two things, they seem, one's a shell and one's a process. So what's,
You could add a
they seem
process.
different.
You could
They're in
add,
conflict.
you could add a process to
But-
line B.
But it says you gotta.
Set up we can make it so it sets up a process, if that's your.
I think the process, Madam Chairman, in C, that's not where I have the question. It's the B creates the shell. It doesn't say shall create a process.
Senator Morrissey.
I think I can, Madam Chair, I think I can
That's what I'm
assuage Senator McDougal's concerns, and I would say this, I love the bill because there's, prisoners need this when they're leaving either it's a jail or DOC. But to Senator McDougal, I would say, B simply deals, when it uses the words shall, it's shall offer assistance to apply. That's easy enough to understand. B then gets to the shall establish procedures. That's where John Jones comes into it, the procedures. I envisage a situation like the following. They need a picture. I don't see a situation where the jail puts them in a van and takes them to DMV. I see a situation where the jail or DOC sends electronically a photograph to DMV. It's merged into this card, and when they exit the jail, they get their card. You don't spell it out in procedures and see, but is that what you envisage, Delegate?
Yes, thank you, Senator Morrissey. And Madam Chair, I would say that the DMV commissioner did visit with me and say that they would be able to assist in this process.
Okay. I think that does add some clarity. May I ask Mr. Edwards, do you have comments, Mr. Edwards?
Madam Chair, Mike Edwards on behalf of the Association of Regional Jails. Could I respond to Senator Morrissey's point? And Delegate Ayers made this point. Several jails are doing this, but several jails are not because there's time and expense involved. One example, Western Virginia Regional Jail, Salem, 4 jurisdictions, 900 inmates a day, 4,800 releases a year. 1 1/4 person's time is nothing but reentry. 50% of that time is working with DMV, health, and Social Security to obtain documentation. So the point that Mr. Jones was making is, if you look at the last line of the bill, there's a cost to jails. That's the point we're making. Thank you.
Madam Chair, and I've shared this with Mr. Edwards in the House when he made the reference as well. This bill specifically does not add in my opinion, a cost. It's allowing them to do much of what's already being done. I'm happy to work with Mr. Edwards in the future if he'd like to have funding support for reentry programming, but this is not what this bill is.
Well, it has to be referred to finance. So the question before our committee is if we like this conceptually, we need to report it out and re-refer it to
Madam
finance.
Chair.
Senator McPike and then Senator Cosgrove.
I'd move to report and refer to finance when the appropriate time if others still have questions. I think this is an important tool and element to reduce recidivism, and it's an important reentry step that we should have a policy framework for across the Commonwealth.
Senator Cosgrove, do you want to speak to that concept? It's not quite a motion yet, but will be.
Yes, Madam Chair. Just speaking of the bill in general, I can't for the life of me figure out why there's not a financial impact statement with this bill. It's obvious cost to the state, the Department of Corrections, but it's also going to be a significant cost to our local jails and all the sheriffs. I mean, if you are getting birth certificates from vital statistics from almost any state, there's a cost associated with that. If you're getting any,
This bill will be re-referred to finance.
well, I understand that. I get that.
Yeah.
But I guess my point is, I can't understand why there wasn't a financial impact statement with it to begin with. There's, somebody dropped the ball.
Delegate Aird.
Thank you, Senator Cosgrove and Madam Chair. As referenced earlier in our conversation, the cost is borne to the actual inmate, and the only time where the cost isn't is if they're classified as indigent, and that's referenced on lines 50 through 52.
Yes, I think we do understand this, and I would like to move our agenda along. Senator Boysko and then Senator Kiggins, and then I think we need a motion.
Madam Chair, I as a sidebar, I would like us to be able to reconsider Delegate Hope's bill in the event that.
Let's deal with this first.
Okay.
Senator Kiggins.
I just had a quick question about where the onus lies. Is it with the prisoner who's been discharged, or is with the jail? That I just know the process of getting a birth certificate and social security card is not easy. So even though we started, or if we give them the paperwork at discharge, or is it simply that, just giving some instruction and paperwork, or do we actually have to follow up and continue to, and that's very manpower intensive to make sure those things actually happen?
Thank you so much, Senator Kiggins. As referenced in the bill, they are beginning the process. Their only responsibility, if they're unable to obtain those documents as amended, it would be to instead then provide them with the actual identification form, which is also a legal form of ID. And if they begin the process while they are an inmate and it is incomplete, the forms completed would be provided to the actual residents on file. So it's not left up to the department, to the jail or the Department of Corrections to continue to try and track down this information.
Okay, so Madam Chair, they do have some responsibility then after discharge to make sure they
No,
finish up
they do not, ma'am. I'm saying that they can start the forms, and then the documents would be sent to not the documents, the actual forms of identification would be sent to the actual inmate, well, no longer inmate, but person who's been released. But there is no onus for them to follow up on that.
Okay, is there a motion, Senator McPike?
Madam Chairman, one more question.
Senator
Just-
McDougal.
This is not, I like the concept. I understand it's just the
I'd like to
words,
try to
words
work
saying
this
what we're
through.
trying to do. I'm only focused on that second section. The
Yeah.
DOC section, I think, is A-okay.
Yeah.
It's just that jail section. So in A, it says that you have to provide the ID, and maybe that's current law now, but, so that means if somebody's arrested for DUI, they're in jail for 6 or 8 hours, now they have to be provided a government-issued ID before they're released, because the 90 days doesn't apply to A. Is that right, Mr.?
Mr. May? I don't.
Because, Madam Chairman, Section A says, prior to release of any prisoner, there's no time limit, you shall issue a special ID card.
After the prisoner does not have already have an ID.
Well,
Fair enough.
So, Madam Chairman, somebody gets arrested for DUI, let's say they don't have their license on them, so before you can release them on bond?
Let's ask David May.
Madam Chair, Senator McDougal, I think it's a fair point. I do think that would be the result. The birth certificate and social security card would be limited to, you have to have been there for 90 days, but for the special identification card, there's no time limitation.
Delegate Aird?
Madam Chair,
Delegate
I would just state that this is not new language that I'm adding to the state code. If you would like to change current law. You're referring to lines 34 and 35?
35, Madam Chairman, a change is made a shall, and the shall requires them to do it before they release them.
On line 36.
On line 36.
You're taking off may and you're saying shall.
And I would ask,
Could you
Madam,
go back to may?
I'm fine with that. I would
Okay.
just say, I believe the special identification card is that legal form with, it's a piece of paper that has their name and their picture on it.
I think I would make a motion that we unstrike the may and go back to may as, would you consider that
I
friendly?
consider that a friendly amendment.
All those in favor of that amendment signify by saying aye. Aye. Okay,
Madam Chair, I move to
Senator
report and
McMichael.
refer to finance.
all right. Please open the rolls.
Thank you, Madam Chair,
14
members
ayes,
of
one
the
nay.
committee.
Thank you.
Madam Chair, may we reconsider the Delegate Hope's bill in the event that this one, having voted on the prevailing side, I'd move
You
that
would
we
like to reconsider the motion
reconsider.
by which we struck
Yes, ma'am.
Delegate Hope's bill?
Yes.
Okay. Well, the bill's pretty simple and for us. Clerk, would you open the roll? Okay.
15 ayes, 0 nays.
Okay, Delegate Hope's bill is now before us. And so Delegate Hope's bill was House Bill 1093, and I will ask Mr. May to explain that.
Madam Chair, so this bill is on the same topic. As you can see, it's a little bit shorter here. It's a little bit more simplistic. It doesn't contain quite all of the language about all the procedures and get into the specifics. And it does have a little bit of a different provision regarding the cost. It says on lines 21 to 22 and 31 to 32 that all the costs and fees associated with obtaining the card are to be paid by the prisoner. It does not have the exception of not having them pay for it when they're declared indigent.
Now, I do have a note from Finance that they want to see this as well. May I have a motion on this and re-refer to Finance? Is there a second? All right, clerk, please open the roll. We'll give them choices. All right, very
15
good.
ayes, 0 nays.
Good work. And maybe we can inform Delegate Hope. Okay. No. All right, this brings us to Delegate Collins. Thank you for your patience. I apologize, we had some other work to do.
Oh, yes, ma'am. I'm well aware. It's all.
Delegate Hope. Delegate Collins.
Good morning, Madam Chairwoman.
Good morning.
Morning, Senators. Bill 1540 is the barrier crimes statutes. There's 3 of them. So the bill does 2 things. First of all, it brings 37.2314 into conformity with 416 as well as 506. We have opened up those other code sections because we have 3 code sections. One is for state employee-operated facilities, one for private facilities, and one for community facilities. And so all through the years, we have opened up one code section, not the other 2. So the first thing this bill does is bring all 3 code sections in alignment with each other. Section C of 314, you see a lot of words there, but that conforms Section C of the other 2 code sections. The other issue here, which is more of a policy decision, is we've added 3 additional misdemeanors to the barrier crime statute, which is domestic assault and battery, brandishing, and prostitution. Now, it's only in the misdemeanors. There are no felonies. If you are convicted of a felony, you cannot be employed by any of these facilities for mental health. But if you were convicted of a misdemeanor, there's the facility may, after doing a background check, hire you to be a mental health professional. And this is filling a need where we have, especially in a lot of communities, especially with the sex trafficking issues that we have going on in our communities around the state at this particular point in time, allows us to engage more individuals who may have the background of this and who have now gotten themselves clean, gotten themselves treatment, and probably know better than the rest of us how best to handle someone else's addiction or mental health issues. So I stand ready for any questions, Madam Chairwoman.
Thank you, Delegate Collins. Are there any questions of the patron?
What did I do
This is a
wrong?
great bill.
Do I have a substitute amendment? I don't know.
Madam Chairman?
Senator, yes, Senator McDougal, and then Senator Mason.
So we're adding in prostitution, which is 18-346. I'm personally good with that. We're adding in brandishing.
I have some people to speak to that.
Okay, that's the one I have
An issue with.
kind of a question about that. And then, Madam Chairman, if we're looking at 57-2, I guess for me personally, that causes a little question for me, and maybe to increase my comfort level, maybe only one conviction of 57-2, because if you have multiple convictions,
I
that
agree. Would you like to offer that amendment?
I would, Madam Chair.
Okay.
I mean, I just.
Why don't you go ahead and offer that amendment as a line amendment?
I'll offer for a.
Would you rather? Yes,
Okay.
okay. Go ahead, Mr. May.
Madam Chair, Senator McDougal, so just to clarify, we were talking about 18-2, 57-2, correct?
Yeah.
Okay, so this would be an assault and battery against a family member, household member, Class 1 misdemeanor. But if there are 2 previous convictions, then it's going to be a Class 6 felony, and it will remain a barrier crime.
Madam Chairman, so you
Senator
have to get
McDougal.
your 3rd conviction of domestic assault before it's a barrier. So if you have 1, maybe I'm still a little queasy, but I'm less queasy. But if you have 2 domestic assault convictions and we're putting you in a mental health position, I think that gives me a little more concern. I think Mr. May's right on the law. That's just me, and I might be on the
There
law.
is a screening process involved here, but Delegate Collins.
Well, I would respond, Madam Chairwoman, I would respond to the delegate, excuse me, I apologize for trying to demote you there, Senator. I think that because we have a first offender for domestic assault and battery, that usually it's a deferral and dismissal, and then there's usually, by the time they have a conviction, it's generally their 2nd domestic assault and battery. So I would find that to be a friendly amendment.
Do you still wish to offer the
Yes,
amendment?
Madam Chairman. I
Okay,
do.
please read, I'll have
think-
Mr. May read the amendment then. Okay, Mr. May.
Madam Chair, so my only other question would be, so that's in addition to the first section of the bill and the second section of the bill, but it is current law in the 3rd section of the bill. So are
This is where
we,
the CSBs are.
would we be applying it, that would be the CSPs, would we be applying it to that one?
Just
as
to
well?
the changes.
Just to the first 2?
Okay.
Okay, so
I don't
those
wanna
changes,
change existing law.
those would be, the first would be on line 28, after 18-257, or we would condition the conviction of 18-2-57.2 on a first offense. That's kind of in concept there. We could say for the first violation of 18-2-57.2, and we would make the same change on line 114 at the towards the beginning of
Madam
the
Chair.
line.
Maybe it needs to say conviction.
That's exactly what I was going to say, not a violation, a conviction.
Conviction, right.
Conviction.
Okay. So is everybody clear on the line amendment? May I have a second?
Senator Serval's jacket is
Senator
making us.
Serval, did you second that?
Sure.
Second.
Okay, all those in favor of this line amendment signify by saying aye. Aye, okay. And also before us is another amendment. Thank you, and all those in favor signify by saying aye. Aye. Anybody opposed? Okay, so we've got the bill as amended before us.
Madam Chair, may I ask one question?
Senator Mason.
So Delegate Collins, what we just approved, the locality can bring this person forward. But then the department has to have, they have a statewide screener or something of the
That's
sort
correct.
that has to then come in, and then, so the locality cannot just do it on their own.
Correct.
They have to have the statewide situation.
Right, Senator, Madam Chairwoman, Senator, that is correct. So this is, there is still a intense background investigation, and there's still someone holding it up. If they say, well, you just got released 30 days ago from jail for your convictions, versus you've been 10 years clean, sober, and out of trouble. That's the difference that we're trying to differentiate.
I think that's great. I don't see any speakers in favor or any opposed, so okay, please come forward. Are you in favor? Okay, very good.
Good morning, Madam Chair and members of the committee. My name is Deidre Johnson, Executive Director of Vocal, which is Virginia's statewide peer-run program representing peers with mental health and co-occurring challenges. I'd like to give you guys just a little bit of background information on this bill for your consideration. I am a peer with both mental health and substance use challenges, as well as a peer that received a barrier crime conviction at the age of 19. I also happen to be the parent of a child with a developmental disability, so I understand the implications of this legislation, the concerns there will be because of this legislation, and the need to protect vulnerable populations. Vocal partnered with SARA, Virginia Network for Private Providers, and VACSB to put forth the legislation to ensure it would be both impactful to the peer recovery specialist workforce, as well as affording those protections to vulnerable populations by specifying its use only in adult mental health and substance use programs. I've been blessed with amazing support throughout my recovery journey and credit the success of both my recovery and my career to services I received from a mental health support specialist that was assigned to me 10 years ago when I lost my newborn son. I received so much more than just mental health skill building because my mental health support specialist was a woman who had lost a child. I credit that support I received with the success I have in my life right now, as well as my recovery. I've also been extended an enormous amount of compassion and grace that's contributed to the success of my recovery and career as well. Unfortunately, many of my peers have not been afforded this same compassion and grace as myself. Virginia's set up an incredibly impactful service by formalizing the peer profession, yet provides no pathway to forgiveness. We have a profession that requires lived experience, yet we're penalized for our lived experiences. Many other states that employ the use of peer services have made significant advancements.
You've done a great job.
I think we're doing, this bill is in, I think it's in pretty good shape. We really admire what you have gone through, and we applaud you for your successes. If you could just conclude in 30 seconds, and maybe the other speakers could just indicate a yes, you're in favor. If you want to say your name and organization, that's fine, but I think you've painted a very complete picture.
Thank you very much. So to sum that up, I'm here as proof to you guys as the successful impact of peer services, and am requesting the same extension of grace and compassion to my fellow peers so that they can go on to live productive lives in recovery.
Thank you very much.
Thank you.
So the others, you're just raising your hand and tell me the organizations, and you're in favor. Okay, super.
Jennifer Faison, VACSB, we support.
Okay, supports the bill.
Mike Ellison, a Virginia Department of Behavioral Health and Developmental Services Certified Peer Recovery Specialist Trainer. Thank you.
Thank you.
Becky Bowers, an Air Substance Abuse Addiction Recovery Alliance.
Thank you. Very good. I don't believe this has to go to finance. Am I incorrect? I don't know.
I don't think that's right. That's not
It
right.
doesn't. This is very exciting. Okay, will the clerk please open the roll?
Thank you, Madam Chairwoman. Thank you, Senators.
Bill reports.
13 ayes, 1 no. Madam Chair,
Yes, Senator Morrissey.
I'm glad to have reported this, but let me make a comment about Senator Collins' bill, and maybe staff can keep this in mind. As I was looking this over, there is in Section B, there was 173 crimes that I counted when I pulled up 19.2, 392.02, that says you can't hire. And then in section C, we had a carve out for 25 more crimes. And then we had a carve out to the carve out.
In this bill.
I have never seen, I've reviewed so many different code sections, and I went through the 11 different ones, including prostitution. There's got to be an easier way to set forth in the code whether there are barrier crimes, as opposed to saying 179, you can't, but we're going to carve out 25, but then we're going to have a carve out to that. Maybe we could have something that says for these 5, 10 crimes, you can't work.
I think that's a drafting question, but I do think that's a good point, because it is a little confusing the way the code was drafted. We're going to keep moving along. Delegate Samara, how are you?
Good, Madam Chairwoman. Thank you so much for having me and
Thank you.
for hearing this bill and members of the committee.
Your House Bill 637?
Correct.
Okay.
Madam Chairwoman, it's just to address the issue of reasonable cost for healthcare coverage. The background to it is the Department of Social Services has a child support program pursuant to the Title 4D of the Social Security Act. And under that program, the division secures child support and medical support orders for families. The bill amends the state law definition of reasonable cost to match the definition in federal regulations. Currently, as it stands, when child support is determined, it's based off of the income of the parents collectively, and we simply want to make sure that the cost of coverage, which is defined as up to 5, does not exceed 5% of currently parents' combined gross income, to be just the income of the parent that is ordered to provide that child support. And that's basically the gist of it.
Okay. Colleagues, do you have any questions?
Yeah, I'm sorry, Madam Chair, I do. I do this every day in court, and I wasn't paying attention. And
All right. Yes, Senator Servo.
I'm sorry. We're changing how much health care costs you're going to cover in child support?
We're changing the percentage from being a total income of the parents to the income of the individual parent that's designated by the court system as the parent that would be providing the child support.
Okay. Further question, Madam Chairman?
Yes, Senator Servo.
So if, say the parent who has the coverage is say a teacher making $50,000 a year, and the other parent is making $1 million a year, we don't count the $1 million a year person's income? I don't understand.
If the court decides that the individual that's to provide the health care is the teacher that's making $50,000 a year, then it would only be 5% of their income if this bill were to become law. Versus if the $1 million parent, the income of the person, the parent that's making $1 million a year is charged, it should not exceed 5% of their income, which would be around $50,000, which obviously is not the average cost of child support for health care.
There are questions. Okay, Senator Kiggins, and then Senator Boysko and Senator Morsi. You're okay. Senator Boysko and then Senator Morsi.
Delegate Samira, could you explain what brought this bill to the body? Why you decided to carry this bill, so we understand a little bit?
Madam Chairwoman, Senator Boysko, the bill was brought to me by the Department of Social Services. They would like to amend the definition to make it easier for the very lower income individuals and parents who are providing health insurance coverage for their children to be able to provide it at a reasonable cost so that it doesn't exceed 5% of their income, and so that if it does exceed 5% of their income, they can pursue other means of support.
Senator Morsi, and then there's a speaker behind you, Senator Morsi.
I think the bill is very practical. Senator Servo mentioned $1 million. Here's an example. Let's say wife is making $950,000, husband is making $50,000, husband is ordered to pay that 5%. 5% of that $1 million is $50,000. He is paying his entire salary. This bill, I think, which I think is practical, says the percentage is directed towards the person that is paying, and that simply is logical and practical.
Okay, there's a speaker behind you.
Department of Social Services would like to speak to it, yes.
Okay. Representative from the Department of Social Services.
Good morning, Madam Speaker, members of the committee. My name is Craig Bersham. I am the State Programs Director, Deputy Commissioner at the Department of Social Services. I think Senator Morrissey gave a perfect example of what we're trying to do here. What we're talking about is only private employer health insurance. So when both parties come into court, and if both parties are working, we're going to look to see if that health insurance that each parent has is reasonable, 5% of their income. So we're only looking at their income. So Senator Servell, in your case, if you had the $1 million parent who had $1 million worth of income, if we looked at their health care, we would determine whether health care is available at 5% of that $1 million. But if you have a parent who is only making $3,000 a month or $30,000 a year, then we look at 5% of that person's.
Madam Chairman.
There are a few questions.
And this is going on with Serval, and it's been a while since I've done this work, but my concern is, I like the goal of helping the custodial parent who is not making a lot of money, but doesn't the court frequently require the non-custodial parent to provide the health care? So isn't this limiting what the court can do to the health care? So my concern is that you're really hurting the child. Because now you have that, under Senator Serval's example, you have that parent who makes $1 million can have an insurance policy that's what, $1,500 a month, and now you're going to be limited to the person who's making the least amount of money, or maybe not even working. So I don't know that that's what you're trying to do, but I think that's what
Because the judge determines who would be responsible for the health care coverage, and
Not
the judge
necessarily
could
the
determine that
custodial
it's the custodial parent who might have less money than the
So,
non-custodial parent.
Senator Serval, I guess my question is
that the
directed to you. Is that, you do this work?
Senator Serval, did you want to respond, or?
Well, most of the, speaking to the bill, so most of the time, the parties agree on, I'm not sure if we're talking about administrative child support or if we're talking about child support negotiated by private counsel. And I know you guys have an administrative system, and which I don't operate in a lot, because that tends to be people that don't have counsel versus child support that's determined in court. At least in court, usually the parents figure out which policy it is. Every once in a while, there's a conflict about it, and the judge has to decide. But that's not very common, but it happens every once in a while. But if there's a big income imbalance, typically the judge doesn't really care what it costs. If some parent makes a lot of money, it comes out in the wash in the child support formula. So they just say, here's the policy, you're paying 80% of it, you're paying 20% of it, and it comes out in the formula. So I don't understand why we're limiting the cost here.
I'm going to ask the department rep to respond.
Madam Chair, Senator Serval, Senator McDougal, I think the purpose of the definition of the federal reg was to balance it. So it doesn't take away the court's authority. The court still has the authority to issue either parent to provide health care if it's available at a reasonable cost. Either parent. As you say, Senator Serval, by and large, when the parents come into court, they have an idea of which parent's going to provide the health care, by and large. They usually agree on that. Yeah. But in some instances where you have one parent who is making a whole lot of money and the other parent who is not, and maybe the parent who is not making only a lot of money, for instance, has the health insurance. And if you add both parents' combined income, it can very much skew how much they have to pay. A perfect example is, and let me maybe just give you a quick example. If one parent's making $10,000 a month and the non-custodial parent's making $3,000 a month, and the non-custodial parent's the only one that has it available through their employer. We're just talking about employer insurance here. If you add those two together, you have $13,000. That means 5% would be $650 that they would have to pay. If you have one child, the child support amount would be $1,261 a month. You would add the $300 health care premium to add that one child. It's only what the incremental cost to add the child. That comes up to $1,561. If you then prorate it based on income shares, and I know this is a little complicated but Senator Servell, I'm sure you're following me, it would be $359 a month. When you subtract the premium, that leaves only $59 a month in cash child support that's going to the custodial parent. So what it's trying to do, what the federal regulation, the definition is trying to do is balance that. They want there to be some cash child support going to the parent, but they also want to provide insurance. And I think in the bottom line here is if healthcare wasn't available at reasonable cost for either parent through their employer, the judge could say, I'm going to ask the custodial parent to go out to the healthcare exchange and see if they can get insurance there. And then when they come back, the judges can make a decision in the best interest of the child.
Senator Morrissey, oh, I'm sorry, are you finished?
No.
Senator Servo.
So, I think I'm starting to understand this, but I'm not clear why it's linked to the parent responsible for providing health care coverage. I mean, it seems to me if, first of all, whatever this health care premium has to be paid by somebody, right? I mean, it's gonna come out of somebody's paycheck. Somebody's gonna get ordered to pay it, it's gonna get paid.
Certainly.
And then on the formula, it's a question of how do we allocate that cost? Typically, it's done by income share. And I think what you're trying to do is limit it to 5% of somebody's income if they don't have a high income. So that means that the other parent is gonna have to make up the difference. And what if, no?
No, it still gets added to the health care, to the guideline worksheet. So you're going to come up with the child support amount and add the premium and then prorate it based on their income shares.
Right.
But remember, whoever is paying the insurance, if the non-custodial parent's paying that insurance premium, you're deducting that whole cost of the insurance from the guideline calculation. So in the example I gave, you're reducing the amount of cash support to the custodial parent dramatically in those few cases where there's great disparity between the two incomes. And that's what it's trying to address.
I think we understand the bill, but Senator Morrissey, did you still want to speak? We're going to have to come up with a motion, colleagues.
I was going to say everything he said.
Okay. All right, the bill is before us. Is there a second?
Second.
All right, will the clerk please open the roll?
Eight ayes, 6 nays, 1 abstention.
Thank you, Madam Chairwoman and members of the committee. Thank you.
Thank you. The only item left on our docket is a bill by Patrick Hope. He had to run up and make another presentation. So it's House Bill 281. Do you have any idea if he's on his way? We can carry this over till next week. Is that okay with you?
So move, Mr. Chairman.
Oh, thank you. Thank you. All right, colleagues, we have completed our business for the day, and the committee shall rise.